Okay. Just, hope I'm audible. Just give me a moment so that we can start the session. Okay. So today we are going to cover Employees Compensation Act as well as waste management rules. And after that, we'll have building topics as Dock Workers Act and Dock Workers Rules and SLPV rules plus ILO collection and recommendations. There are four topics we have to complete. Apart from maybe next week, we will completely finish the IS 105. Okay. Um, I'll start with the Employees Compensation Act. Continuing that, we'll discuss hazardous waste management rules. Hope you are able to see my screen now. Sandeep Kumar Sahu. Regarding the exam date, if I'm not wrong, I think they are yet to announce. For better and authentic information, you better check with the institute. Screen not showing. What about others? Let me share again. Can you please check now? Yes. Shivaram Reddy, just check now. Fine. So this act is called as Employees Compensation Act, basically where they'll get the compensation based on this act. So we'll start with a couple of definitions. So basically, we will understand what is meant by compensation. They've given simple that whatever the compensation which is provided by this act. ఏంటంటే ఏదైతే compensation అనేది ఎంప్లాయీస్ వస్తుందో దాన్ని మనం compensation అంటాము. And also, before going to that, we have to understand few definitions with respect to this act. To whom this compensation goes? Sometimes it goes to the dependent. ఎప్పుడైతే ఒకసారి మనకి డిపెండెంట్ కి మనకి కాంపెన్సేషన్ అవుతుంది. డిపెండెంట్ అంటే ఎవరు? Either the parents or the family, whoever the family members are there, it will go for to them. Means any of the following relatives of deceased. Okay. So here we'll majorly talk about employer because he is the person who pays the compensation. ఎవరైతే ఎంప్లాయర్ ఉన్నారో వాళ్ళు బేసికల్గా ఈ కాంపెన్సేషన్ అనేది విక్టిమ్స్ కి పే చేస్తూ ఉంటారు. విక్టిమ్స్ అంటే వర్కర్స్ అవ్వచ్చు, లేదా కొన్నిసార్లు outside people. So sometimes what will happen, the victims may be the employees of his own, or sometimes the people from outside the organization. If you say an employer includes any body of the persons, whether incorporated or not, and any managing agent of an employer or legal representative of the deceased employer, and also when of services, either temporarily or lent, means contract or hire to any another person by the person who with whom the employee has entered into a contract or service or apprenticeship, means of such person while the employee is working for him. It is simple that any person who has given an employment, either direct employment or indirect employment through contractors, he will be called as an employer. So again, other definition, partial disablement. This is the one. From the day when we are talking about partial disablement or uh, complete disablement. So if you see a partial disablement means where the disablement is temporary in nature. It is simple that it is partial, means not fully. It is temporary in nature. Such disablement as reduces the earning capacity of the employee in any employment in which he has engaged at the time of accident, resulting in the disablement. It's simple that the disablement is temporary in nature. As I take an example as any fracture or any injury or anything, the employee is lost his earning capacity due to that disablement. Then qualified medical practitioner, it is not so important, but it is required to understand exactly. So it is basically means any person registered under the act, provincial act or any act of legislator or state providing the maintenance of a register of medical practitioners or in any area who has such last mentioned this act in the force, any person declared as state government by notification of official gazette will be qualified as medical practitioner. Basically, the state government will release an official gazette stating that who are the uh, qualified medical practitioners. Those people only will be treated as medical practitioners. Then total disablement. This is also one of the definition. See, if I say total disablement, such disablement, whether a temporary or permanent in nature, as incapacities of employee for all work which he has capable of performing at the time of accident, resulting in such disablement. In the sense, when he was doing an activity before accident, but after the accident, he is not able to perform the same activity because of his disablement, which is resulting due to the accident. దాన్ని మనం permanent disablement or total disablement అంటాం. This also may be temporary or permanent, but mostly it is permanent in nature. If I say total disablement, most of the times or 99.9% it is permanent in nature. For example, loss of limbs or loss of hand, loss of eyes or loss of hearing completely, all those. Then a wage. The wage also, it is not an example where you can get in exam, but everybody knows what is mean by wage. It includes a privilege or benefit which is capable of being estimated in money other than traveling allowance or the value for the traveling occasions or contribution paid by the employer of an employee towards any pension or provident fund, and also sum of paid to employee to cover any special expenses entitled on him at the nature of his employment. It is nothing but it is an inclusive of so various benefits all together the employer will pay to the employee at that tenure. ఓకే, టోటల్ డిజేబుల్మెంట్ అంటే మనకి పర్మనెంట్ గా మన అవయవాల్ని కోల్పోవడం. వచ్చి ఎంప్లాయర్ లైబిలిటీ అంటే ఎంప్లాయర్ యొక్క విధులు ఏంటి అంటే ఏంటంటే లైబిలిటీ ఎలా చెప్పొచ్చు, రెస్పాన్సిబుల్ అని చెప్పొచ్చు. సో ఈజ్ ద అకౌంటబుల్ పర్సన్ అని కూడా చెప్పొచ్చు. సో if any personal injury is caused to an employee, any accident rising out of or in the course of his employment, his employer shall be liable to pay the compensation in accordance with the provisions of this chapter. So in case of any accident happen in his premises, or if somebody met with an accident, so the employer is responsible to pay the compensation, provided that the employer shall not so liable. So basically, if something happens, he is going to be liable, but in certain cases, he is away from such liabilities in case of he is not so liable in respect of any injury which does not result in the total or partial disablement of employee for a preceding exceeding 3 days. So in case ఏదైనా injury, in case of any injury which has happened, which is not exceeding in respect of injury which does not result in the total or partial disablement of the employee for providing exceeding 3 days. అంటే ఏంటంటే మనకి 3 days కంటే తక్కువ ఏమంటారు డేస్ వాళ్ళకి కనుక ఇది అవ్వకపోతే వాళ్ళకి కాంపెన్సేషన్ పని లేదు. సో వాట్ దే డూ ఇస్ దే విల్ ప్రొవైడ్ ది మెడికల్ ట్రీట్మెంట్. And also in respect of any injury not resulting in death or permanent total disablement caused by an accident which is directly attributed to the employee having been at the time of and also under the influence of drink or drugs, and also the willful disobedience of employee in order to expressly given or rule expressly framed for the purpose of securing the safety of employee, and also willful removal or discarded by employee of any safety guard or other devices which he knew to have been provided for the purpose of securing the safety of the employees. So other cases, one is if he is not exceeding 3 days of his disablement, then the employer is not supposed to pay any compensation. Other cases, in respect of any injury not resulting in death or permanent total disablement, but he caused because of willful negligence or under the influence of drugs. Simple that whenever an employee comes under the effect, he had took the alcohol or he came for the duty, in that alcoholic condition, intoxicants condition, he met with an accident. And also willful obedience, disobedience. Disobedience in the sense he is not following the safety rules and regulations, and also willful removal or discarded of safety guards, which are supposed to be used during his employment or to secure. In the sense, for example, there are PPs are required. The employer has given proper training whenever he is doing any such activity. So specific PPs are supposed to be used to perform, but the employee is not using. Then in such cases, the employer are not liable to pay any compensation. Okay. This is the basics you can have. Then amount of compensation. So subject to the provision of this act, the amount of compensation shall be as follows, where the death result and from the injury, an amount equal to 50% of monthly wages of a employee multiplied by the relevant factor, or an amount of 1,20,000 rupees, whichever is more. So if you see here, by this, nobody will go. This is under the Employees Compensation Act. Okay. So if you see 1 lakh, it is a very small amount. So as per the rule, that is the amount, but basically the compensation will pay in a different manner. So whenever any death happens, it is close to 1,20,000 rupees, where a permanent total disablement results from the injury, an amount equal to the 60% of the monthly wages of the injured employee multiplied by the relevant factor, and also or 1 lakh and also 20,000 rupees, whichever is more. అంటే ఏదైతే ఎక్కువ అమౌంట్ ఉందో దాన్ని ప్రిఫర్ చేస్తారు. Then compensation to be paid when due, and also penalty for the default. Under this section 4, in case of any employer does not accept the liability for the compensation to the extent claimed, he shall be bound to make provisional payment based on the extent of liability which he accepts, and also such payment shall be deposited with the commissioner or maid of employee, as in the case of maybe without prejudice